What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we are back in the Lori Vallow trial as she represents herself, asks the questions, tries to provide some kind of defense as the state continues to build a narrative, a motive, a story that is seeming to fit into place, even if the investigation maybe was not great at the time and didn't get to the right result as they thought it was, in fact, self-defense. Up until the Idaho case, and everything started to crumble for Lori Vallow. So we will continue to watch today. Also, some very interesting jury questions. Whenever the jury can ask questions, I always love to get into their head, see how they're viewing a situation, and see what we can learn from it. So if you guys are following this case, make sure you hit the like button, and let's get to it. So we broke yesterday as Lori Vallow was trying to testify through this witness and get in her version of the events and facts of what happened. The judge has explained to her that that can't happen. He's also explained to her the state's about done with their case. They might be done today, Wednesday, April 16th, which is the day I'm recording this, the day you're going to watch it. And if they are, and you haven't properly served any of your witnesses and none of them show up and the state doesn't know about them and they don't have the opportunity to talk to them, you may be precluded from basically calling everybody. Will she get up on the stand herself and just give a narrative testimony of some sort? The judge said she can't. She has to give questions to her lawyer. Is that what's going to happen? Is that going to be her entire case in chief? Is she going to play any video, audio recordings, enter any pictures, anything? What is she going to do in the defense of her case? We know she wanted to call witnesses. They've tried to help her, but here we are. So the detective is back on the stand that interviewed Sheehan Tiley. And she talked about the fact that you didn't ask to see threatening text from Charles. You didn't look at his phone for them. Why not? Why didn't you look for him? She tries to say Charles stole her phone, and that's why she had multiple phones. She had to get another one. But again, she is trying to testify. And then she focuses in on her demeanor yet again. So let's listen to a little bit of this cross.
I'm going to object here to knowledge and foundation as to her knowledge of this.
I'll sustain the objection.
Did you offer Tiley and I apple juice at the Chandler Police Station?
I think I offered you something to drink and what we typically would have there.
Did you offer that for the purpose that adrenaline makes you thirsty?
No, I usually do it to people I interview if they'd like something to drink while they're there.
Detective Inkland, have you ever seen me not calm?
Very weird question. I get where she's trying to go. That like, I'm always calm. It might seem weird. And by the way, before you trash this, I'm pretty sure this is exactly what Bryan Kohberger's team is trying to do. Bryan Kohberger's natural vibe and natural personality is one that people would find weird, is one that people would have a negative feeling towards. And Lori Vallow's like, maybe you just don't like my natural personality. It's calm even in stressful situations. And she tries to dig in, and we'll talk about why this doesn't end up getting through, but it's a very interesting discussion.
I'm going to object to maybe foundation as to when.
All right, sustain, lay more foundation on when she has, at what occasions she has had to observe you.
Well, yesterday you spoke often of my calm demeanor, my nonchalantness. Is that correct?
Correct.
So has there ever been an occasion when you have seen me when I was not calm?
Again, foundation as to when she.
I totally disagree. I think she can answer the question and say no, but as she keeps pushing, and if the judge is going to make you give specifics, that's where you fall into you can't do it because you might open a very big door you don't want to.
I've seen her on July 11th.
Please clarify the time frame you're referring to where she had an opportunity to observe you.
Any other time, Your Honor?
For example, how many hours?
I don't think she has to do that. Like, I don't think she has to give an example. Like, if you've only seen me twice, we've had people testify that have only talked to her 2 times or only known Charles for 7 days. And they testify like whatever their observations are, which is fair. Of all the times you've observed me, we don't have to go through each individual one. If there is one you've seen me not act calm, then go ahead and say it. But again, that could open the door.
On July.
Can we have a sidebar? Can I ask you a question?
So she doesn't end up getting to go really much further into this. And the reason is this witness could have, I'm not sure if she did, but she could have seen Lori Vallow on TV interviews, during her Idaho trial, during investigations and interviews and questioning about the Idaho trial. And we definitely don't want to bring that in if we're Lori Vallow, right? And so the judge is like, you don't know what you're doing here. You're about to open the door. And I've had a lot of people ask me, is the judge going too far? Is he giving her legal advice? Should he just let her dig her own grave? And the answer is no. He's not going too far. This judge has let Lori Vallow make plenty of mistakes that she is entitled to make, and it is her right to make. But he's also warned her a lot, and he's protected from opening the door, because if you really get into what happened to JJ and Tylee and what Lori's been convicted of, this case is over. She's for sure going to get convicted. It'll become a big appellate issue. So you'd rather have as fair of a trial as you can. And I think that's what the judge is trying to do. And I think he's done well balancing, helping her out a little bit, but also letting her make her own mistakes. She also goes into depth about how cooperative she and Tylee were throughout the process, which I do think is good. On redirect, they also focus on the demeanor again. They get out that Lori was the problem. She was the initiator of this fight because she kept her phone, which a lot of you guys said as well. Legally, I don't think that's enough for like a self-defense type of deal. But I think it's an argument that jurors, obviously, if you guys think it's important, that jurors may be like, yeah, she started this whole thing anyways, even if Charles was doing something, which was he actually swinging at anybody with the bat is still, remains to be seen. And then she finally gets into, which to me, this is just something you have to say, right? Like Lori Vallow has made it pretty clear that they weren't arrested that day. And she has tried to make it seem like we were cooperative. Nobody arrested us. Everybody believed it was self-defense. That's kind of the vibe the jury might be picking up from Lori Vallow. So the prosecutor is dealing with maybe not the best investigation in the world. Maybe they missed some things. Maybe they didn't do some things they shouldn't have, and provide an excuse for that basically. And her excuse that she's providing is you didn't have all the information at the time. And so she's going to go into that a little bit on redirect. I thought it was interesting. So let's listen to it.
Your interview with the defendant. Did you understand all the facts of the case when you interviewed the defendant?
No,
You told us you didn't understand the timeline yet in terms of when the shooting occurred versus when the 911 call occurred, right?
correct,
So you were unaware of that 47-minute lapse in time.
correct.
If you had known that, would you have asked about that?
I would have asked about that, yes.
So when did you find that out? If I was a defense attorney, I would recross and say, so when did you find that out? Because you definitely found it out and still didn't arrest her, right? Because they didn't arrest her till much later. Why didn't you look into the timeline? Isn't that part of the investigation? Because if you looked into the timeline and that was such a big deal, you should have arrested her back then. So there's a lot of follow-up I would have had if I was a defense attorney, but Lori Vallow is doing this herself. So instead, the state is providing a pretty good excuse.
When you were interviewing the defendant, you were unaware that she had Charles's phone, correct?
Correct.
If you had known that, would you have asked about that?
I would have asked about that, yes.
She found out she had Charles's phone like 5 minutes later when they went back to the house and they handed it to her out of the cup holder. So you did find out about Charles's phone eventually. It's not like it was 6 months later you found out about that. Again, all questions I would ask on cross.
When the defendant was talking to you at one point, she told you that she knew her brother was texting with, or that Charles was texting with her brother Adam. Do you recall that?
Yes, she told me that.
Understanding now that she had Charles's phone, would you have asked her how she learned about that?
I would have asked her about that, yes.
That doesn't make any sense. Why didn't you ask her at the time how she knew about that? You still should have. You didn't have to know she had Charles's phone to ask her how she knew about that. This redirect, if you're not with the prosecutor, right, this redirect to me would make me question this whole investigation. Now, Lori Vallow is not going to make the jury do that.
So when you're doing an interview with her at 9 or 10 in the morning, you didn't know that she'd had time to look into Charles's phone?
Correct.
You learned later that she had the password to get into his phone, right?
Correct.
So when she's telling you things, you're unaware that she has already potentially had the ability to access those.
That's true.
also, because Lori has already set the foundation of how cooperative she was, they went to the police station, they talked to them, they would have gone back. Everything points to they would have gone back. You could have had another interview right after you found out she had Charles's phone and asked all these questions that you're saying in court here. Oh, I would have asked, but I didn't know at the time.
And what she's telling you in her interview contained information about the interaction between her brother Adam and Charles.
Right.
When you interviewed the defendant, were you aware of the days leading up to this, the interaction between Lori Vallow and her brother Alex?
I was not.
You weren't privy to things like iCloud accounts before you interviewed her?
No,
You weren't privy to downloaded cell phones before you interviewed her?
I was not.
And some of the information sure came later, but some of it did not come that much later, right? And you could have tried to interview her again. Did you ask her to do an interview at that point?
You hadn't even been inside the house before you interviewed her.
Correct.
If you had been privy to all of the information in this case, would you have interviewed her differently?
Objection, speculation. Now we're speculating. We don't know what she would have done.
I would have.
Would you have questioned her more?
Yes.
Would you have followed up more?
Yes.
Would you have asked for her phone then?
Yes.
Feels like an admission of a not great investigation.
When you interviewed Lori Vallow, at that time, were you just going off of what she said because you didn't know the rest of the facts
Correct. It was an initial interview.
to see what she had to tell you?
Correct.
The audio is brutal at parts. So that's basically the end of the redirect. But then I do also want to play the jury question because I thought these were really interesting to get into the mind of the jury here. What questions do they have for this witness based on everything we've heard this witness testify about?
All right. Question form number 12. If the defendant and her daughter were interviewed as witnesses, why were they left with a victim advocate? In other words, were they considered victims or witnesses?
So our victim,
That's an interesting question. Are they thinking, well, did you guys think they were just witnesses or victims at the time? Do you still think that? Interesting. If that's what a juror's thinking.
services section, I introduced Lori to them specifically because there are civilian employees that work within our police department that can help families with death investigations for the issues that come up afterwards and kind of navigating that process. So although they might not be classified under like state law as victims, our victim services section will often help our families with like specific crisis type events and navigating that process. So we use them quite a bit in our death investigations.
I'm going to try refreshing this just to see if it helps that audio at all.
Navigating that process. So although they might
I don't expect it to, but if it's a little better, then great. Okay, so I thought that was a very fair answer of her. I think it was a correct answer. Did it really drive home the point the prosecutor wanted to drive home? No, and just wait, because on redirect or on follow-up from this jury question, the prosecutor is going to lead this witness to the lawyer basically answers that question for the juror in the way the lawyer wants to answer it. And because there's no defense attorney to object, she basically gets to just speak her answer to the jury to argue to the jury why they weren't victim and witnesses. So just wait for that. But there's another juror question.
Number 13. Did Lori express concerns about police talking with Tylee at the time of the interview?
she did not.
There were also questions about parental consent, whether it was appropriate. The judge did not allow them to ask that. There was also a question from the juror, did Lori Vallow ask for a lawyer, which the judge did not allow them to ask. And to me, both of those answers would have been good for Lori Vallow. They didn't properly ask for her consent. It sounds like, I don't know all the details because we didn't get into them. And she didn't ask for a lawyer, I don't think, which most jurors, even though I would never hold it against a person, I think she should have asked for a lawyer. I think everybody should ask for a lawyer. I think most jurors, if she didn't ask for a lawyer, might think, is she really lying or did she really not do anything wrong? And she wasn't scared. That's why she didn't even think she needed a lawyer. I found those questions to be interesting.
Does law enforcement have to advise interviewees they are being audio and or video recorded?
They do not. There is no expectation of privacy within a police station.
All right, are there any further?
That's absolutely correct. But again, at least one juror is worried about, were Lori Vallow's rights trampled on? And I love that. I think that's a great juror. I think that's exactly how I should look at this case. I don't think it should be a not guilty verdict necessarily because of that, but I do think it's important for that to be on the forefront of a juror's mind to make sure a police investigation was done appropriately regardless of who the defendant was. And I think they asked the appropriate questions. They gave the appropriate answers. And basically listening to that, it doesn't seem like any of her rights were trampled on. They didn't get into the minor stuff. And would that have made a big deal? Maybe, maybe not. The lawyer stuff as well. But again, very interesting questions. And I think at least one juror's mind is on, the right stuff. Probably more than one, but I'm just saying based on those questions. So now let's listen to the follow-up and how the state basically gets up and answers the jurors' questions for them, for this witness, instead of just relying on what this witness said.
Further juror questions at this time? Not seeing any. Would the defendant like to follow up on those juror questions?
No, Your Honor.
State?
Just briefly, with regards to introducing Lori entirely to your victim services, were you trying to provide whatever services might be necessary due to the fact that her husband had been killed?
Correct.
And what you assumed at that point was Tylee's dad or stepdad had been killed.
Correct.
And again, this is all prior to you learning more about this case?
Correct.
No other questions, Your Honor.
All right.
The reason all this happened is because you didn't know enough about this case, right? And they were only treated that way because you didn't know enough about this case. Once you found out, they would not have been treated that way, right? Correct, correct, correct. Leading questions, the state getting to basically answer the jurors' questions because there's no defense attorney there to object. Next up, and I believe there was an issue with the witness for today, so that's why yesterday was shorter. And this was the only other witness. They did, play videos of Lori Vallow going to Burger King, but this was the witness that basically was the cell phone expert. The data that he got from the cell phone just didn't line up with Lori Vallow's story. Lori Vallow wanted to make it seem like all this happened in 12 minutes, but actually it was 40 minutes from the shooting to calling 911. And I think that is a huge deal because if it is an accident or it is self-defense and you really care about somebody, as soon as the shots are fired, you're calling 911. You're not letting them lay on the floor and bleed out as a family member of yours. I think that is incredibly damning evidence. She went to Burger King and CVS or Walgreens and dropped JG off at school all in 12 minutes. No. More like 40 minutes. And they go through all that, how she left the scene at 7:52. 911 wasn't called until 8:36. She comes back to the scene at 8:48. None of that really makes sense. And I thought he summed it all up very good in this last minute. And after a lot of technical evidence, again, they also have the video of her going to Walgreens and buying the flip-flops because they ran out without shoes on. And again, some of it seems like it was frantic, but then some of it very much does not, right? Especially with her demeanor and things like that. So the final minute of his testimony basically summarizes what he found. It's always a good tie, like a guy with a little bit of flash like him. But he's going to basically summarize, here's what we found from the cell phone data, a really good final wrap-up question by the state. I thought this was a key, important witness, objective evidence, logical evidence. You can't get around with any arguments or explanation or manipulation from Lori Vallow. This was very damning to her. The way he set it out methodically, I thought he was a really good witness personally.
Gentlemen, phone seats to stay off or you will be asked to leave the courtroom.
Somebody's getting yelled at because like a phone went off or something.
It's not primarily my case. Beyond that, I would have done whatever else I was asked to do, but I wasn't asked to look at other days in this case.
So ultimately, what you determined was that the timeline of Lori Vallow leaving when the 911 call was and returning back was not accurate.
Yes, as I understood, based on, again, the multiple different ways now that we're able to corroborate location not only of devices that are relevant, because we knew at this point that she had Charles's phone. We knew numbers for her phones. We have video of her at various places. it led to the inescapable conclusion that either the shooting did not happen that close in time to the 911 call, or that she wasn't there for the shooting. I could not see a third way of interpreting that data.
Thank you. I have no other questions.
She's lying about something. Either she wasn't there for the shooting or they waited way too long to call 911. Frankly, it would have been better for Lori Vallow if she wasn't there from the shooting and she was just regurgitating what Alex told her. But I guess maybe not, because her entirely needed to be there for the self-defense. So either way, Lori's story unravels. It falls apart. This is, I think, the most damning evidence that could get the state to beyond a reasonable doubt proving this case. Because the investigation wasn't great. They thought that it was self-defense. Then, a lot of other stuff happens in Lori Vallow's life and they come back to it. This witness, I think, was extremely important for the state to prove this case against Lori Vallow. And let's get into now Lori Vallow's cross-examination of this witness and see what she does for potentially one of the most damning witnesses against her.
Detective Werther, you had submitted a report on 12/26/2009.
I don't know if it's because I was listening to it on 2x speed. I don't remember the audio being this awful, so I'm sorry, but just bear with me. We're not listening to a ton of it. There's only like 5, 6, 7 minutes left of audio we're going to listen to.
Is that correct?
That sounds correct.
And have you had a chance to review that at all before your testimony?
Yes.
Okay. So you found some interestingly contrasting things in your report.
She found some contrasting things that were interesting to her in his report. What is that going to be? The timeline does match up, that there are witness statements that don't corroborate what his timeline says. Is that what she's going to focus on? Something super relevant to this case? You might be asking yourself that question.
That you reported on that date. You made a note of his daily text message of love and devotion to me. Do you remember that?
I do not.
Okay. Then you also made a note of his interactions with women he was attempting to date. Is that correct?
I do remember that.
Okay.
So what is this big contrast she has? What's contradicting in his report? That Charles was sending a daily text message about how much he loves Lori and yet texting other women that he's trying to date. And the guy's like, okay, yeah, I do remember that. It's like, that's the big zinger she has. No relevance to what happened in this case, but just now trying to trash Charles Vallow a little bit to make him look like some kind of womanizer.
Detective Werther, in your report on page 103, you indicate that Charles went to the airport to meet Florence Hughes and found that she
Object to
never boarded.
relevance.
Is that correct?
Hold on.
Object to relevance.
What's the relevance of that?
It's just in his report, Your Honor, and I was just going over it to see if,
Well, everything in a police report isn't necessarily relevant. Well, how's it?
Judge is right, but I don't love this discussion in front of the jury. And Lori Vallow's like, yeah, I agree. It has no relevance. I want to talk about it because I saw it in the report.
Relevant to this case?
it's relevant to show what was going on in this, right before this happened. These
Right.
events happened within June and July.
All right, it's the objection sustained.
Did you learn who Florence Hughes was?
I'm going to object again to relevance.
Sustained.
In your report, Detective, you find evidence that Charles did in fact send someone $1,000.
I would object to relevance again.
Sustained.
I would object to relevance to all of these types of questions.
When you had, what was your role in going through the data from the phone, from my husband's phone?
So primarily I went through the location data because of the concerns we had about timeline. I know I went through other data associated with other accounts, but I don't believe I specifically went through the phone extraction outside of the location data.
Okay. But in your report, you made a lot of notes to these things, but that wasn't what you were looking for. You just happened upon it? How did that happen?
So there are things found, I think many of those may be related to a Google account. And yes, as certain things were being accomplished as a team, sometimes you'll task out and say, would you look through this to see what you find that may be relevant? And it isn't always clear up front in an investigation what's going to be relevant. So when I see communications between people without knowing the full story, particularly when I'm not the primary case agent, I may note things because I want to make sure the case agent knows of them so he or she can decide if that's a thing that needs to be pursued further. And if they think it is, then they can ask me or someone else, or they can do it themselves. But that would be why some of those things are documented.
Okay. And you wrote them in your report because you thought they might be relevant?
Yes, not knowing the
And she's trying to get into like, well, stuff in your report is relevant, isn't it? Stuff I wanted to ask about is relevant, and they wouldn't let me get to it.
full case, I noted things like that that may be relevant.
And that would need to go to the case agent so he could decide if those were relevant or not as well.
Correct. The case agent has much fuller information, particularly as a long-term investigation goes on. As somebody who's just helping out with certain tasks, it's not always obvious to you what things are going to be relevant to the person who knows the entirety of the case.
So you mentioned in your report that on July 10th, there was a scheduled phone date with Nancy Jo Hancock. Is that correct?
I think I did indicate that in my report, yes.
Okay. And then on the next day, there was another date scheduled with a Jennifer Gilbert at 12 o'clock.
That sounds correct.
And then the next day, there was another date scheduled with a Juliet at 10 a.m.
And obviously trying to smear the victim.
All right.
Not a proper objection at all, but not a proper line of questioning by Lori Vallow. So the prosecutor decided to combat that with, she's trying to smear the victim, which again, nobody on the jury is going to like. Lori Vallow can feel however she wants about Charles Vallow. I promise you the jury's not feeling that way.
The objection sustained.
She won't give it up.
Detective, did you find searches for these dates
Madam
for my
Chair,
husband back
Hold
to?
on.
If we can do a
Hold on.
sidebar.
Sustained.
The judge does not look happy right now. He's looking at her like a child in his class as a teacher, like, stop it.
This is a different question,
No,
Your Honor.
whether he went
He's like sustained. No, don't do it.
on dates or had.
This is a different question,
No,
Your Honor.
whether he went on dates or had dates scheduled is not relevant to this case.
Correct.
Ask another question. You can ask about the date of the person that testified the night before because that person was in here and had some relevant information. But other than that, any of these other questions are not relevant.
Detective, you talked about going with Detective Moffett to the hotel room where you found my husband's laptop. Is that correct?
That's right.
Okay. And then was also his iPad in there?
I believe so.
And then you said some suitcases,
Correct.
maybe his briefcase was like a rolling suitcase?
It may have been, we may be describing the same thing differently. I didn't personally inventory the items. I helped.
They go through some, procedural ways that he collected evidence and items from the hotel. But they do finish on this note, which I found interesting. I wasn't really sure about his answer, but she asks about the threatening text from Charles again. Nobody can prove they didn't happen, which is very weird because they extracted her phone. They make her sound like a liar saying that he sent threatening texts, but they can never really confirm that, which I found was weird. But this is the cell phone guy. And he already talked about lovey-dovey texts or whatever that Charles sent once a day and communications he had with other women. So this feels like the guy that would answer the question about whether or not Charles sent threatening texts.
$2 million life insurance policy Charles had on me.
I'm not aware of that.
Seems like nobody is.
In the course of your investigation with my husband's phone, did you come across the threatening text messages from him to me?
I don't believe I saw text message content from his phone. From the phone, I restricted what I was looking at to the location data I'd been given.
So now he says he didn't look at the text messages in his phone. He restricted his location data, but in his report, I thought he had the once a day lovey text or whatever that he sent to Lori Vallow, the contrasting things that she found in his report. So I found that kind of strange.
I'm not aware of contents of the phone.
Okay.
And that was pretty much it. So short day in court, shorter day here for us. The state believes they will be finishing today, which is wild. And Lori Vallow may have no witnesses. So this case could literally be done tomorrow. They could do closing arguments, or it could go into next week. But I think very early next week, probably before the Karen Reed case even starts, this one is going to be over. But don't forget, we have trial number 2 with Brandon Boudreaux that Lori Vallow will once again be representing herself in. So if this case really is over, we're going to start putting up some polls and see where you guys are, what you think the vote's going to be. Make sure you guys hit the like button. Make sure you are subscribed to our channel. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.